This is Mike Franklin, the property tax guy, and I got some a crazy story for you today. Before I get into that, I want a little update of additional counties that I've worked in. I'm up to 34 right now. Let's see, I've added Chemung. Let me see, Sullivan, Albany, and Rensselaer. Let's see if there's any others. But anyway, we're up to 34 counties so far participated in these matters. And oh yeah, Allegheny. Did I say Allegheny? Um, anyway, but today we're going to talk about the city of Syracuse's Board of Assessment Review and their extremely unprofessional and childish behavior. I've never seen anything like it before. These people are out of control. I just I don't even know where to start with them, but I'm going to share the screen and look at a response that they have. Okay, so I'm going to go here, and this is the Board of Assessment Review. The guy in the center is Joe Saya. Now he wrote the decision on one of my cases. The guy on the right is deputy assessor. His name is Joe Kaya, something like that. This woman on the right is on the Board of Assessment Review. She's a retired paralegal. It's good experience to be a retired paralegal, but I don't know what it has to do with real estate valuation. This guy here on the left is Carl Masterpole. He's an independent insurance agent. Again, I don't know what that has to do with real estate valuation, but his brother was a city auditor, so I guess that's how he's qualified. The woman on the left worked for home headquarters, I guess some sort of contract function. I don't know what that has to do with real estate valuation. Josiah is a real estate broker, some sort of, I don't know, financial planner or something. I don't know, but he's got real estate experience, but what you're going to see in his decision is kind of concerning. So here's the decision he wrote on one of my properties. Now, keep in mind, this case, I had one nearly identical last year that was right across the street from this property. And so Mr. Saya had the following to say about this. The Board of Assessment Review has received the grievance on your property at 209 Paris Lane in the city of Syracuse. A hearing regarding the property was held on February 14th, 2024, in which you were represented by Michael R. Franklin. That would be me. Mr. Franklin was designated in your application for grievance as an agent qualified to speak regarding the property. At the hearing, Mr. Franklin indicated that he had not performed an inspection of the property and documented a complete unfamiliarity with the property, even as basic facts as the inventory or the date of purchase. I did not personally inspect the property, and I never do, and I never will. I don't go inside people's houses. It's an invasion of privacy. The assessor cannot go inside people's houses. There's no reason why I should be going inside of anybody's houses. I analyze the property in the same way that the assessor does, through the data, through photos, through street view, things of that nature. And as far as the purchase date of the property, it's just, it was, we're talking about either the 2021 or 2022 year. It's just kind of ridiculous. The Board of Assessment Review has determined that Mr. Franklin is not sufficiently knowledgeable to speak regarding the property and therefore cannot currently qualify as a viable agent of the property owner as it pertains to the actual value of the property. I just don't know who this guy thinks he is, thinking that he can choose who's somebody's legal representative is. If I'm not qualified to represent this property, I'm just wondering who is. My qualifications versus the members of that board, there is no comparison. These people don't even have the qualifications to know what I'm talking about. The board finds it difficult for an agent accurately representing the state or value of the property when the agent has no knowledge of the inventory renovations that have been performed with or without permit or the details regarding the sale and purchase of the property. Well, from my perspective, those details simply were not relevant because the city selectively assessed the property. It's illegal, and the value must be returned to the previous level when they do that. So that's the argument that I was there to make. I wasn't there to talk about what kind of tile he had in the bathroom. When an agent is found to be insufficiently qualified to represent a property owner, the owner is provided an opportunity to make a second appearance and ensure that our agent is sufficiently familiarized with the property. Designate an alternative agent for a follow-up appearance, or 3, personally appear for the follow-up appearance. Mr. Franklin's appearance and representations were strictly limited to claiming the property was selectively assessed. Well, that part is true. But I think what they're suggesting is that they would contact my client and propose a different representative. And to me, that would be a tortuous interference with my arrangements with my clients. And I just don't know who these people think they are. Would they, if somebody, would they do that with somebody's attorney? Say, hey, your attorney just, he's not very good, so we think you should get another one. These people are crazy. I don't know what the purpose of this is. Maybe his butt is hurt because I roughed him up in a Board of Assessment review. So if you want to know what really happened at the hearing, on my assessor audit page, you can see the entire hearing, so you know exactly what happened. And my clients know exactly what happened. They watched the video themselves. Unlike claims regarding a difference in value, claims that a property was selectively assessed do not necessarily require an agent to intelligently and knowingly familiarize themselves with the value of the property. That's true. That's true. If the argument for selective assessment, there's really nothing else to talk about other than that they selectively assess the property. And I believe I've established that they did selectively assess the property. Let's see. Selective assessment is an assessment in which is based solely on the sale of the property or renovations done with a permit. It is frequently referred to as welcome stranger law. And the prohibition on selective assessment is designed to prohibit municipalities from unfairly levying taxes on newcomers to the municipality, which is exactly what happened. The guy bought the property and they pinned the purchase price. By law, they may be able to do that, but they need to demonstrate how they brought the other properties in line with this sale. The city needs to be very careful about this because they're at a 62.5% equalization. And, if you're going to pin them at 100% and everybody else is at 62.5%, well, that's not good. And that's kind of the problem that we're having here is that, they find the sales and they immediately address them, and that is not legal. That's the point there. So, but the city's under pressure to get the equalization rate up, so that's why they pin these purchase prices, and they do it routinely. On this block alone, they did it 3 times. And let's see, I'll get into. I'm going to show you the decision from last year because they made the same arguments last year, and then I had to beat them at its scar. When a claim of selective assessment is raised, testimony is limited to the facts surrounding the sale and the increase in assessment. The board therefore finds it would be against public interest to disqualify Mr. Franklin and require an alternate appearance when presented with claims of selective assessment. So they're saying that I'm not qualified, but because he's talking about a selective, we'll let it go for now, which is awfully nice of them. Mr. Franklin claims that the assessment on the property was selective and must be reduced to $80,000. In support of his claim, Mr. Franklin points to an assessment that was first increased on a tentative roll in January 2023. The board disagrees with Mr. Franklin's claims. Yeah, they disagree, but they don't say how. It's just so because they said so, I guess. The property was purchased in an arm's length transaction more than 2 years ago, on or around 2021. And the assessment, well, look at that. He doesn't even know where the purchase date was. Jeez. And the assessment was not raised until the 2023-2024 year when a claim, well, that, I guess they didn't get it right for 2021-22 then. When a claim of selective assessment is made, the board looks at multiple factors such as the date and underlying facts of the sale, the price of the purchase, whether any renovations requiring permits were done, and the full market value reflected by the tentative assessment of the property. Well, it's awfully good of you to look into that kind of stuff, but I don't see you drawing any conclusions from it to support your position. The board, other than saying that I'm not qualified, the board believes that when a property is purchased and more than 1 year passes before an assessment is raised, the increased assessment is not an increase based solely on the sale of the property, provided the assessor raised the assessment follows a standard neighborhood by neighborhood review of properties. Well, that's the problem. He didn't follow a standard neighborhood by neighborhood review of properties. The 10 blocks north had no increase. There was the property next door had no increase. The property kitty corner across the street had no increase. So there wasn't a standard, and they believe because a year has passed that it's not valid. That Welcome Stranger wasn't executed in that particular year. It's ridiculous. The property was purchased in 2021 for $156,000, while the full market value of the property reflected in the tentative assessment roll is $158,400. During Mr. Franklin's testimony before the board, that he stated that the assessment was pinned to the purchase price. Given the length of time between the purchase date and the increase in assessment, the board finds it unlikely that the assessor selectively assessed the property. Well, how did you find it unlikely? Because the sales price is almost identical to the assessment. So how can you find that? I'd be curious to know. For the above reasons, the board denies your application for a reduction in assessment, finding the city did not selectively assess the property. So that's what it is that they have to say. But here, look at this one here. This is when you're denied at bar, which we just were, then you go to small claims assessment review, where you go before a state hearing officer. Now, that board of assessment review was appointed by the same people who appointed the assessor, so don't expect a different result from them. They're just kowtowing to the assessor, and that's pretty much what they do. But when you go for a small claims assessment review hearing officer, they don't work for the city. They weren't appointed by the common council, and they were, and they usually have actual real estate valuation experience. In this case, the guy's a real estate broker, and he's been a hearing officer for literally 40 years, the entire duration of this law. So, who's been doing it longer than this guy? Anyway, so this one is 209 Parish. So it's kitty corner across the street. And it says, and he wrote, this is last year, where we had a very combative bar hearing. They had two lawyers and deputy assessor full in the SCAR hearing. And I just beat the guy over the head. It was hilarious. So here's what the hearing officer had to say. The subject property was sold at a non-arm's length transaction. The new assessment was possibly a result of the sale. Welcome to the neighborhood, which is Welcome Stranger. Other similar sales were also raised at a higher rate than existing homes not sold or transferred. The requested assessed value does include a 7.5% inflation factor. Since no marker appreciation number was supplied by the city, this number seems fair and consistent with the area. Fair market value is set at $132,923. So the hearing officer didn't agree with them. They made the same argument last year, but it was determined to be a Welcome Stranger violation. And last year, the assessor refused to provide me with his comparable sales report. I finally got it at this hearing, and later when I had an opportunity to review it, 4 out of his 5 comparables that the assessor chose, he had pinned the purchase price. So 4 out of the 5 comparable sales that he used as comparables for this property were also illegally assessed. And so, these people are ridiculous. And then they're bashing me in a public document, very unprofessionally, very childishly, because their butt is hurt. I'm assuming. I think they're accusing me of being incompetent. But what's kind of funny is that because they weren't giving me my data, I had to sue them in state Supreme Court, and I beat their legal department, and pro se. So if I'm incompetent, what is their legal department? So that's what's going on with the city of Syracuse. It's generally they just check a box that says insufficient information, even when you provided volumes of information. They usually write nothing, but I hurt their butt so bad that they provided this elaborate response that is disparaging me falsely. So again, I encourage you to go to my assessor audit and watch the actual hearing itself, and it'll give you a pretty good idea of the truth of what it is that transpired. No, I didn't get into the details of the interior, because it just wasn't relevant. If they selectively assess the property, none of that matters, and so we didn't discuss it. So this is Mike Franklin, the property tax guy, an assessor audit on YouTube.